Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi weekly community conference call every other Thursday. Today is September 7th, 2017. As always, I will go over the questions that I have identified as frequently asked questions first. At the end of each question, I will of course ask you for any follow-ups, anything that you want to ask me that relates to the question or the issues I've just discussed. Feel free to bring that up. That said, I want to begin by discussing the first question about denial of naturalization applications, and I've called it the new trend. Under the Trump administration, I am noticing that there has been a much higher incidence of naturalization applications getting denied for some of them are very odd reasons. I'll give you an example. In yesterday alone, just yesterday, I have done 3 consultations on naturalization denials. And I'll give you an example so that you folks can share it with other people and tell them to be mindful before you file naturalization application. Discuss your case if you have anything in your background that you're concerned about. Discuss your case with a lawyer. Make sure that it doesn't end up that you go for naturalization and government wants to come after your green card. So be careful. 3 cases that I discussed yesterday. One was an employee who had been a green card holder now for 6-7 years and applied for naturalization. Government denied his naturalization, saying that when we approved your green card, your 485, we should not have approved it because you were working in a place where you were not authorized to work without getting a proper amendment back in 1989 or 1998, sorry. So they've actually gone back so many years to say that because of that, your green card was approved in error. It should not have been approved. And of course, we are not going to give you naturalization. Now, interesting thing is that I actually told them that I had represented the company that was being hauled up for fraud, only to the extent that I wanted to negotiate upon the employer's request with the US Attorney's Office so that the employees don't get hurt, because none of the employees was implicated in any of the fraudulent or allegedly fraudulent dealings. They were doing their job as best as they knew how to. They had no reason to suspect. So, but I was not able to convince the USCIS. We were able to get the US Attorney's Office on our side and make them see reason that, look, these innocent people do not need to suffer. The employees don't need to suffer. But we were not able to convince USCIS. So the result is several years later, somebody's naturalization is being denied. Of course, we are going to take up the case and we're going to fight it for these folks. I think it's ridiculous to bring that up at this point of time. See, the problem is, if you are saying my naturalization cannot be approved because my green card was approved in error, that means you're going to go after my green card, right? So that is the next logical step, and that's what worries me. I think that's highly unfair. The second case I again looked at yesterday, and this is a similar case. I've seen another case like this. The employer signed a form 9089 according to the government that was fraudulent because they failed to disclose the relationship of the employee with the CEO of the employer. The lawyer had told them that, look, this is a far removed relationship. It's not immediate family. So you can say no to the 9089 question where it says, are you related with the employee under the green card process? And they said no. And their naturalization is being denied because government says you lied on that form. Again, we would be able to fight this case. The third case is even odder in some ways. People have lived here for 15, 16, 17 years. Everybody in the family is a citizen. The lady of the house is not a citizen, applied for naturalization, but in the meantime, husband got a great job offer, temporary job offer outside the United States. And government says, well, you're going to lose your green card. They've just moved recently. And I don't see how they can do that. So when you apply for naturalization, not only naturalization can be denied if there is even a little bit questionable in your background. I don't see how it is questionable. Some of these things are outrageous, but we've got to be prepared for the new paradigm of immigration law. That's just the way it is. So when you go for naturalization, I strongly advise you to please discuss your background with counsel. Okay? Now, the question before me from Annie is this. She had in her background a marriage based upon which she got a green card, and they didn't get a divorce, then she met somebody else, etc., etc. So the question is, am I going to have any problem when I go for my naturalization? What I would suggest, Annie, is that please talk with a lawyer, discuss every aspect of your case, not just so. To the extent that I'm asked to give you an opinion, and to the extent that I can give you any opinion based upon the facts that you've given me, I can tell you this. You need to have a detailed consultation with the counsel so that whoever reviews your case feels comfortable that government, even though they are behaving rather oddly during these times, they'll be able to protect your case. So please have a consultation with competent counsel. Let's have somebody go over all your facts and make sure there's nothing in your background that's going to come back and hurt you. Star 5 if you have a question on this. Star 5, question on naturalizations. Star 5 if you have a question. Press star 5 on your phone. Okay. Next question that I've marked as frequently asked question is about the I-485. Jai Vijay or Vijay says, let's say my priority date becomes current and it stays current for the next 5 years. Am I constrained to file my 485 right now, or can I wait 5 years and file my 485? And the answer is, there is no law that requires you to file the 485 right away. But I'm trying to remember if there is anything. There could be some issue about H1 extensions. So if you have, your lawyer should look at it. There was some mention of this sort of a situation in the January 17th regulations also. I don't remember off the top of my head, but you certainly will not be able to get 3-year H1 extensions. Of course, you can work on EAD, but there is no law, to the best of my remembrance, that prohibits you from applying for your 485 you can't do EAD if you haven't filed your 485. But there's no law that says you can't file your 485 some years down the line. Okay? Star 5 if you have a follow-up question. Star 5. Okay. Let's go on to the next frequently asked question. Now, there is a follow-up question. Let us go to Pennsylvania. Go ahead, Pennsylvania.
Hi Rajiv, I have a question regarding this. So when the 485, when we want to file, do we need to work for the same employer, or we can be on a different employer? And in case if we are with a different employer, do we need to provide any letters like a verification letter, employment verification, or any other things we need?
Okay. A 485 can only be filed if the sponsoring employer, whoever sponsored the underlying green card, has a job for you, the same job that was in the green card, and you have the intention to join them. So therefore, when you file the 485, you must have a genuine offer letter from the employer who sponsored you. You can't have another employer file 485. But what you can do is, if you move to another employer, the new employer can redo your green card and they can inherit the priority date of the old green card. Then you don't need anything from your old employer. Clear?
All right, Rajiv. Thank you.
Oh, you're welcome. Good luck. Okay, so let's go on to the next one, which is how to answer this question about status and unlawful presence in the form DS-160. Now, folks, I have said this before and I'll say it again. We cannot help you fill out forms because if we help you fill out forms, then we must sign those forms. If you look at the bottom of most forms, it'll say whoever helped you fill this form should sign here. So I can't do that. But I can tell you this, in general. This is a very generic statement. Do not depend upon this statement as the last word on the subject. Generally speaking, the following 2 or 3 rules should be kept in mind. First of all, if you are ever in doubt, you are better off saying yes, I was out of status, and yes, I was unlawfully present, and let the consulate deal with that issue. If you are in fact not out of status and you are not unlawfully present, there is no issue. Okay? But if you were out of status or unlawfully present and you don't reveal it, that can be construed to be fraud or misrepresentation, which then becomes a permanent bar from entering the United States. It is a very painful situation. If you tell the truth, no issue, 99.9% of the times for most people. If you tell a lie, permanent bar. So, of course, again, discuss with your lawyers before you do this. So, whenever there is a gap, like for instance, there is for Srinivas says there was a no pay stub from 1st Jan to 5th April. Now, remember, this is not a big deal. But anytime you have a gap in status or any such hiatus, you should always discuss with counsel, the lawyer who processed your H1. I answer these questions by assuming that I was out of status. Because remember, being out of status is never a bar from getting a visa. Never. Being unlawfully present for 180 days or more is a bar. But less than 180 days unlawful presence or out of status is no problem. I'll give you an example. We had a case many years ago where a doctor, a physician, had worked on a 1099, not on a W-2, but on a 1099 for a hospital system that employed, I think, 500 or 600 physicians. And they were giving all these H-1B physicians 1099s instead of W-2s because of some advice that they either misunderstood or they were given bad advice by lawyers that H-1B employers can give 1099s. So all these physicians had been out of status because they were receiving 1099s, and they were out of status for over 2 years. This physician who was our client, upon our advice, went back, got a visa stamp and came back. Full facts revealed, no problem encountered. Mistakes can happen. So normally, being out of status even for X number of years is no issue. Being unlawfully present, which is a term of art, normally unlawful presence begins upon expiration of the I-94, but don't depend upon that. There are too many variations in that theme. So once again I repeat, whenever you have a situation where you're doubtful, better off saying yes, I was out of status, and yes, I was unlawfully present, and then deal with it. When you are out of status even for years, it's not an issue. Getting a visa corrects it. If you are unlawfully present less than 180 days, you never have to worry. I hope that makes things clear. *5 if you have a follow-up question on this. *5. press star 5 on your phone. I have one from Ohio. Anybody else? Okay. Ohio, go ahead, please.
Hi, Rajiv. So my concern was because earlier I had a consultation with you related to this issue. So at that point, what you said was like, since my H-1B amendment was in process at the time of no pay stubs which I have, it's sort of a logical situation. So it's not considered to be out of status. As you said, it's a debatable subject. So I just want to make sure, like, so since my H-1B amendment was in process at the time of where I don't have the pay stubs, so is it still considered like unlawfully present?
First of all, you have to forgive me because I wouldn't remember. First 4 hours of every working day, I do consultations, one every 15 minutes. So you can imagine how many consultations I do in a week. I won't remember exactly what we talked about. But let me quickly take a look at your facts. So, employer A, H-1B amendment filed on 5th August 2015. And you said withdrawal acknowledgement. So, in other words, they withdrew it after filing the amendment?
Yeah, so I was off the project from 31st December and they raised a request for withdrawal. So it got reflected in the website that this amendment has been withdrawn on 6th April.
Okay. Okay, I'll come back to that. Give me 1 second. So 5th August to 6th April. That's one. And in between, no, before that even, before the withdrawal, 8th March, there was, oh, that's the acknowledgement. Employer B, H-1B filed on 8th March. Okay. Employer C, H-1B filed 5th April 2016. And you said that the last H-1B was approved, right? 5th April 2016? Okay. Now that...
It was approved, so I withdraw from employer B.
Okay, okay. Hang on. And that H-1 was approved with an I-94?
Without I-94, so I exited the country and came back,
Okay.
so I got an update.
So you were definitely out of status, at least that's what the government thinks you were. You see, when they don't give you an I-94, it is their adjudication that you were out of status. You see my point?
Okay.
So,
Yeah.
and if I were you, I would say yes to, in my view, I can't help you once again fill the forms. I would probably think that I was both unlawfully present and out of status. But it doesn't look to me like there was a discontinuity. Let's see. 6th April, they withdrew. Before that, 8th March, they had already filed, another employer. And that was on 24th May. Employer C filed on 5th April 2016. So you've got cases pending all the way to May 2016. Something is pending. So I personally feel that you were not unlawfully present because of the continuity, but you were out of status. However, if I were you, I would say yes to both these questions. In my view, they both appear to be in the affirmative. And I don't think it's going to be a permanent bar. If you want me to take a look at the case again, we can set up another call for you. But why spend money on a consultation with me? You can talk to your lawyers who did the H-1, have them go over the details of your case. I personally think you're okay, but I cannot comment authoritatively and completely without going over the case again. But it doesn't look like a major issue. Okay?
Okay.
And you said you've already gone and gotten H-1 visa stamping done, right?
No, so I'm about to go now. So earlier I went on my existing visa, the old, which was with the old company. So I came back on the same old visa.
Oh, okay.
So now
when did you enter USA?
It was in April 2016. I exited USA.
Okay. So I feel that there is nothing here that's gonna cause you any problems, but I would still want you to review it with a lawyer, make sure, because see, the problem is the bars attached to you when you leave the country. If they had to attach, they've already attached, frankly, because you left and came back in 2016. But as a lawyer, I can't say that you shouldn't have this looked at, but as a member of the community, as having had these kind of situations for myself as an immigrant, I would not worry about it, but I would still want to address it. I don't think it's going to be a problem for you in the long run. Okay?
Okay.
Good luck.
And the concern is like I'm eligible for drop-off, so I'm not sure if I put S, there might be further issues or delayed in my stamping.
Yeah, this can definitely cause delays in your stamping. How much, whether they're going to hold you there for 3 weeks or 3 months or 6 months, I cannot say. But if you do not err on the side of too much revelation, you could end up being in a situation where they hold you, okay, you committed misrepresentation. For me to remove misrepresentation from your record would take me a year and a half. I know how they deal. It takes us forever to deal with these situations. So it's better to err on the side of caution. Okay?
Okay.
Good luck, sir. You're welcome. Okay, let's go to the next frequently asked question. Oh, I have no other frequently asked questions. Okay, so let's go to the non-frequently asked questions one by one. From Anne, this one is, my visa and I-94 expired July 2017, but extension was filed last year, October 2016. We received an RFE, responded. Project ended on August 15th. I'm on leave till September 2012, still getting paid without a client project. But then if I don't find a new job, I'll be asked to go back by my current employer. So employer A says, if we are not able to find you a project by September 12th, you gotta go back. Okay. While waiting on a decision by USCIS today, August 26th, I again received an RFE. So you got a second RFE. That can happen. Since I don't have a client project, how can I respond to this RFE? Can I use the same document? See, I don't know what the RFE is. Only thing I can tell you is you can never ever misrepresent anything. In fact, there are a string of cases that I remember reading where even concealing a material fact was considered to be misrepresentation. So not only can you not lie, you also cannot conceal a material fact. I'm not quite sure what the legal soundness of the concealment doctrine is, but government does take that view. Okay, so be careful with that. And also, yes, if you have a currently pending H1 and situation changes, you can always file an amendment. So if you get a new project, you can file an amendment and you can respond to the old RFE with a response saying, by the way, that project is now gone. Here is the new RFE. That project was good, it was sound, it was approvable, but here is the new project details and we filed an amendment. You can do that. If I find a new job and try to transfer, you see, the thing is, I don't really know what the grounds for denial would be. I don't know your case, but normally, if it is just a routine case, the fact that you're filing another H1 through another employer, worst case scenario, it only means you have to go outside USA for visa stamping. It doesn't mean that you're going to get a permanent black mark against your immigration record. I don't see that happening. Okay, so what would I do if I were in your situation? I would definitely want to file an amendment because you need a project or a transfer over to a new employer and respond to the RFE, because I think all employers should respond to RFEs. If you don't respond to an RFE, I certainly think it's a suspicious mark against the employer. Always RFEs should be responded to. *5 if you have a follow-up question, and or anybody else has a follow-up question, *5. Okay, we've got 1, from Minnesota. Anybody else? Okay, let's go to Minnesota. Minnesota, go ahead, please.
Hi, Rajiv. So thanks for your answer. So my question is that since my extension is pending and we have got a second RC, and my I-94 and the extension was expired on August 7th. So this time till I get my extension approved, I am in the status pending stage. So at this point in time, if we file an amendment and say, for example, my employer is not able to provide enough documentation for my previous project because that RFC was raised for the previous project. So in that case, if in worst case scenario, if that extension is denied, then technically I would be considered as out of status, correct? Like till my next amendment gets approved or whatever the case is, because my extension which was applied for after August 7th is now denied. So technically speaking, I will be said out of status and I will have to depart, and then my employer will have to apply for a new H1 for that new amendment, if I'm correct.
Okay, let me explain to you how it works when you have a series of amendment, extensions, transfers pending. In a situation like yours, I'm not going to give you a generic answer because there are too many details. But in a case like yours, once August comes when your I-94 is expiring, you are still in authorized period of stay, as you rightly observed, because you have an amendment extension pending. If another employer applies for you for a transfer while the previous case is still pending, the second case could be approved only if either the first one is already approved when the second is decided. Once again, second case will be approved with I-94 only if the first one is already approved when the second case is decided, or you can prove in the second case that the first filing was approvable when filed. As a practical matter, unless they respond to the RFE in the first case strongly enough, chances are you are going to have to go outside USA for visa stamping. Okay?
Okay. So this was even after the expiration of I-94. If the first RFE was not, the first case was
Yeah,
not
if that gets denied, it is almost certain you'll have to go outside USA for visa stamping.
Is it, in that case, my whole H1 will get denied?
No. Okay, let's separate the two things. Getting an I-94 within USA means government thinks that you are in status or that they excuse you are being out of status. Okay, so once again, when you get an I-94 approval, it simply means government accepts your status. When you don't get an I-94, you can still get the H1 approval. You take that approval and go to the consulate for visa stamping. You can go to a third country, Canada, Mexico, Jamaica, wherever you like, or to your home country. Clear?
And this is with respect to the same employer amendment?
It doesn't matter. It can be a different employer. Same principle.
Okay.
All right? Good luck, ma'am. Let's see. Next question is Vipul. Applied for H4 and H4 EAD renewal under C26. Receipt date is June 6th. Current H4 is good till September. Can I get a temporary H4 EAD? No. Can I continue working? No. There is no other way to continue working. You see, categories like H4 EAD do not have a grace period. But categories like 485 EAD have a grace period to continue working if you timely filed an extension up to 180 days. But not for H4 EAD. You have to stop working, and I don't know of any other way to get, there's no temporary EAD. *5 if you have a follow-up question. Okay. Let's go on to Prakash Soni. Oh, there is a follow-up question. This is from Pennsylvania. Pennsylvania, go ahead, please. Pennsylvania, we can hear you. Pennsylvania. Area code 412, we can hear you. Hello?
Yeah, my question.
Yeah.
Can you hear me fine?
I can, yes, sir.
Okay, my question is about consular processing.
I'm not taking new questions. Unless your question has something to do with H4EAD, we'll have to wait till the end. Okay?
Okay, sure.
All right. Sure. Okay. Going back to Prakash Soni says, there's a girl who's a green card holder for 2 years, wants to marry a boy on F1, who's in USA for 1 month. You see, there are 2 more questions. Okay. Let's go back and deal with those 2 questions first. This one is from California. Yeah, California, we can hear you. Go ahead, please.
Hi, Rajiv. My question is, I'm on H1 and my extension is pending, and which my employer put it on the level 1. So I got a RFE for level 1.
Okay, hang on 1 second. 1 second. It has nothing to do with H4EAD. Please wait. If we have time, we'll take new questions. Guys, don't ask me new questions. Yeah, just wait for the end. If I have time, I'll call out for new questions. I'm only answering the posted questions right now. Maryland, if you have an H4EAD question, only then raise your hand. Otherwise, press *5 and put your hand down. Press *5 if it's not H4 related question. Okay, we'll go to Maryland. Go ahead, Maryland. We can hear you.
Yeah, Rajesh, I have a question on H4EAD.
Yes, sir.
I'm on H-1B and my I-140 is approved.
Okay.
My wife is on H-1B and her I-140 is approved.
Okay.
I'm planning to go on her H-1B using I-140.
Sure.
So my question is, if I continue, my green card has been filed by my current company as well. If I continue with my current company and if I change to EA, is that still possible?
Of course.
And second question.
Of course it is possible, and it's done all the time.
Okay.
Situation like yours and your wife's is quite common. Both have I-140 approval. One decides to chuck the H1 and go on EAD. Your green card can go on through your own company. It doesn't require you to be on H1. Second question.
Okay, second question is, let's say, since this was an executive order passed by Obama government, and let's say the current government...
No, stop. H4 EAD regulations were not an executive order. They were regulations.
Okay.
They were regulations. Regulations cannot be taken away by a stroke of Trump's pen. Executive orders can be taken away by a stroke of a pen, normally, unless they are illegal, which is being challenged. So, to take away H4EAD would require time and trouble. You can always go back to H1 after converting to H4EAD. No issues.
Okay, so if I stay with my current company, currently in H-1B, if I change to EAD, and let's say after I continue to stay with my current company, after 2 years, for some reason, let's say something happens and I want to change back to H1, so is that a smooth process?
Yes.
As long as I'm the same company.
It is, even if you are with a different company, it is as smooth as anything in H1 filing can be. By the way, just to give you an idea of how tough things are, I reviewed a response prepared by our team today, H1 RFE response. The response was 91 pages long. Just the response, not the exhibits, just the response. That is how hard we often have to work on H1 cases. That said, if you're on H4EAD, 5 years down the line, you decide you want to go back to H1. Number one, you are not subject to the quota because your H1 has been approved within the last 6 years. So no quota issue. Second, you are on H4. So you can convert to H1 within the United States by filing for an H1. So either way, going from H4 to H1 should not be an issue. Okay?
Okay, and my green card will continue to process.
Absolutely.
And once let's say
Yeah.
I'm the E2 category.
Yeah.
E2 category, so after 10 years or 5 years, when it becomes active, I don't have to be work with current company or have an H-1B status.
That's a different question.
I can be-
That's a different question.
Okay.
That's not the same question. It cannot be said in the same breath. That's a totally different discussion. I've actually touched upon it today. Listen to the conversation that Monica will post. Listen to the conversation we had about 10 minutes ago, and you will see when can we file a 485 through an employer with whom we are not working. Okay?
Okay, I will do that. I will do that.
Good luck.
Thank you. I appreciate that.
You're welcome. Okay, now we have one more question from Pennsylvania. Let's go to Pennsylvania. Pennsylvania, go ahead, please. Pennsylvania, we can hear you.
Hi, thank you for taking the question. So my question is, my wife is on H4 EAD, and if I move to Canada and work for a U.S. company in Canada and travel like frequently to U.S., my wife can still work in U.S.?
I don't have an answer for your question. It's a very difficult question to answer. Why? Because in order for an H4 to have H4 status, the H1 must be maintaining H1 status. If the H1 goes away for too long, in your case that's how it is, or they are on intermittent visit, I'm not sure you can maintain H4 status like that.
No, well, 15 days in U.S. and 15 days in Canada. Is it possible for me to maintain that?
I think there is no clear-cut answer to that question. But I haven't researched the law. I haven't spent time poring over all the various nuances of regulations. USCIS regulations are quite complex, and many times government itself doesn't know what it's doing. I'll give you an example. I was reviewing a court testimony in a federal case in which I am giving testimony as an expert witness eventually. And I was surprised at how poorly informed government's own adjudicators were about the regulations. So, regulations are quite complex. I cannot really answer these questions without reviewing everything. Sometimes we have to go into the history of regulations. But based upon what I do know, unless you are maintaining H1 status and physical presence in the United States, I think maintaining H4 would be difficult. Okay?
Okay, because there are people traveling every day from Canada.
That's different. Every day is different. But once every 15 days or 15 days here, 15 days out, that's a different situation. So I'm not prepared to give you a definitive answer because I don't know it. I don't want to make an answer up just to please you. Okay?
Sure. Thank you.
You're welcome. Good luck. I can tell you what the difficulty is, but I don't know what the answer is. Okay, now I'm definitely going to the next question. Prakash Soni, girl is on green card for 2 years, wants to marry a guy on F1 who's here for 1 month. See, here's my problem. If somebody enters the United States and within 30 to 60 days decides to go for a marriage or a long-term visa change, government can take that to be, and I think they might have some substance to it too, that you already had this plan when you entered USA. So in almost all these cases, I don't think it's a good idea. Is there a waiting period for marriage for filing petition for him? I will not want to answer these questions in the abstract. In general, I can tell you this, anybody who enters the United States on one visa while having the intention towards another visa can be in trouble. Marriage genuineness is not the issue here. The issue is the intention of the individual who entered the United States. And yes, there can be considerable restraints on mobility, because if you are on a student visa and you applied for a green card and you travel outside USA, government could stop you at the airport and say, well, sorry, you're going to have to go back. It looks like you're an intended immigrant. You are not entitled to a non-immigrant visa, unless the visa is something like an H1 or an H4 or an L1 or L2 or O visa, where you are allowed to have a dual intent. I think this individual should go on get their semester or two out of the way, and then you folks can discuss marriage. Um, of course, if you become a US citizen, you can always upgrade the petition. But while the green card is pending, traveling on F1 would be difficult. Maybe you can even postpone it to the time till he gets his H1. So it's difficult. It's difficult to give you an exact answer. I guess you are on the phone and you're on a voice over IP, so I don't really know where you are calling from. Let's talk to you. Go ahead. We can hear you. Go ahead. You can hear.
Hi, Rajiv. This is Nisha.
Yes,
I
ma'am.
had a question related to this.
Yes.
This is regarding the K1 process. So my fiance has made a petition for K1, which is in process right now.
Okay.
And my question is, will I be able to travel to the US to meet him to attend a friend's wedding using my tourist visa?
The answer is there is no law on this. Your chances are unpredictable. If at the airport the Customs and Border Protection officer is not convinced that you have a genuine reason to visit, they can turn you back. Worse, they can formally refuse you entry and bar you for 5 years. Those are the chances you take. But then again, if the customs officer is reasonable, realizes that you've come and gone, I'm assuming you've done this before, right? On tourist visa? Ma'am?
Yes, I've gone to yes, I have gone
Yeah.
to the US on tourist
So,
visa.
so if somebody was reasonable, they should let you in, especially when you have a reason for marriage. You're not here to overstay your welcome or any such thing. But it's difficult to predict. There's no law prohibiting you, but there certainly is a matter of discretion at the airport. Okay?
Right. So if I have my return tickets booked and if I, display
Still
that,
doesn't
like my
doesn't
return
doesn't
ticket,
doesn't
then-
make doesn't make you immune to a denial.
Right.
Okay?
So you're saying it's risky.
It's risky, yes, ma'am. Good luck.
Thank you, Rajiv.
You're welcome.
Thank you.
Okay. So then we go on to the next question, which is from Sam8825. Currently on STEM OPT extension, good till 31st May 2019. Company A filed an H-1B. It got picked in the lottery, but then there were layoffs. I was laid off. Company A said they won't be withdrawing the H-1B application. My H-1B is in pending status now. Is it possible for me to join Company B before October 1st, 2017? And then tell them to transfer my H-1B on October? I think so. Because until, even if your H-1B, but hang on one second though. We don't know whether your H-1B was approved or not. Let's see. Currently on STEM OPT extension, Company A filed for H-1B, got picked in lottery. Okay, so until and unless your H-1B is actually approved, you are still not exempt from the quota. Okay, so this is a very difficult situation to comment on. You must be actually H-1B approved and change of status approved. If both these things are true, then you can file a transfer, H-1B transfer, before October 1st and continue working on your OPT in the meantime. Star 5 if you have a follow-up question. Star 5. Okay, no follow-up question. Baldwin 3 says, currently on STEM OPT with Company A, B applied for H-1B, got picked and approved. Can I transfer H-1 to? Of course, you can. If you've got a change of status, I just answered that question. If you have a change of status approved, you can apply for a transfer over even before October 1st, and as long as your previous H1 is not revoked before October 1st, the transfer should go through. Star 5 if you have a follow-up question. Okay, let's, there are two follow-up questions, one from Illinois, one from Missouri. Let's go to Illinois first. Illinois, go ahead please. Go ahead with your follow-up question.
Yeah, this is about the Prakash Soni question.
Yes, sir.
The green card holder, the girl, she's here for 2 years, but she was out of USA for 8 months. So
Yeah,
whenever she applied,
I
she
don't think I don't think that by itself is a problem because she was out for completing her education. So, and then after that, she's been here working for 1 year. I think that's not an issue by itself, sir. Okay.
she will be eligible for naturalization after 4.5 years, right?
Actually, she might be eligible in 3 years, not 4.5 years, because even though she was outside for more than 6 months, it was for a very good reason. It isn't because she abandoned her green card. So chances are she'll be eligible for citizenship in 3 years.
Thank you, sir.
You're welcome. Okay. Next question is from Missouri. Yes, Missouri. Go ahead, please.
Hello. Hi, Rajiv. So this is Ballin 3. So I just wanted to know, I know you mentioned that, I can transfer from my other company to this one, but I wanted to know if I do transfer, will there be any issues or questions that, might rise or any common questions that you
No,
might ask?
no. We do this all the time. As far as I know, USCIS
Okay.
has not changed its policy. The policy is
Okay.
if you received your change of status and your H1 is not, please double check it with your lawyers also, but I believe this to be the policy.
Okay.
That if your H1 is not revoked before October 1st and you've got a change of status, you can transfer over to any employer even before October 1st. Okay?
Okay.
Good.
And how long does the process usually take?
Now,
How early should I get this transfer application in?
You should file it right away.
I'm sorry, can you repeat that?
Right away, as quickly as possible.
Right away. Okay.
Yep.
All
Okay.
right. Thank you so much.
You're welcome. Okay, then the next question is from Kumar Sena. I'm on H-1B, changed employer A to employer B. Transfer is good till November 2018, but my spouse got only till November 2017. But we both have a valid visa till 2018. So, first of all, you don't have to apply for her H4 extension because you are planning to travel. Once she goes outside, she can return on the same visa that she had before, which is good till 2018, and she will get an I-94 good till 2018 when she appears at the airport. So, if you want to not go for visa stamping, you can for your wife. Okay? And eventually, before her I-94 expires, the one that she gets at the airport for 2018, you can apply for her extension within the United States. Star 5 if you have a follow-up question. Star 5, follow-up question. Okay. This one is also from Illinois, another one from Texas. Okay, Illinois, go ahead, please. Illinois.
Yeah, Prakash Modi again. This question about their waiting period. Whether they can...
Okay, Prakashji, I'm going to indulge you this one last time. I can't keep going back to your questions. So, one last time I'll do it, but I won't do it again. Go ahead, what is your question?
Yeah, only thing is कि उनको क्या शादी के लिए राह देखनी चाहिए या शादी करने के बाद फाइल करने के लिए राह देखनी चाहिए?
I think for both. They should wait for both.
Okay, thank you.
You're welcome. Okay. Folks, it's interruptive of a narrative and our conference if we keep going back to your questions. Ask me all the questions in one go. I won't go back to your questions if you neglect to ask them. It's very interruptive of other people and we do have a limited amount of time. I was hoping that I'll get time to do new questions. It doesn't look like I'm going to. So going back to, let's go to Texas. Texas, go ahead, please. Texas? Yeah, Texas, we can hear you.
Hello. Yeah, hello, Rajiv. This is from
not sign up.
Yes, ma'am.
So I can travel with my husband, right? Coming back, I'm leaving on October 2017.
Absolutely.
I'm traveling to.
Yeah, you have.
So
Yeah, see, because you have a visa stamp which is good till 2018 and you are leaving USA before your current I-94 expires, you do have the choice to travel back on the old visa stamp even though your husband has changed employers and even though your husband has H1 for a longer duration. When you come back to the airport in the United States, they will give you an I-94 till 2018, which is the visa stamp you have.
Okay.
Okay?
Okay. Thank you.
You're welcome.
Thank you very much.
You're welcome. Good luck. So, Akash ji, there's not much we can do when they decline your student visa. Very difficult to challenge a student visa denial. I think the most we can do is write a letter to the consulate explaining your background, explaining how you've come and gone so many times, or at least a couple of times. One thing that goes against you is the fact that last time you were in the USA, you started looking around for a school while you were still on a tourist visa. So, not sure I can do much for you, but I can try, or any lawyer can try. *5 if you have a follow-up question. Mira99 says, if I'm on H1 or H4, how do I adopt a child from my home country? And the thing is, from what I remember, the definition of a child for H4 purposes is this. 1, the child was validly adopted under the laws of the country where the child was adopted. So if you adopt a child in India, it must be a valid legal adoption in India. Or if you adopt a child in UK, must be a valid legal adoption in UK. The second part is more tricky. Then you must have maintained physical custody, or I think they call it custody, of the child for 2 years. Now, I don't remember exactly how that provision works. Do you physically have to be in India or your home country? Or can, for example, the child comes and lives with your parents and you decide where the child goes to school, what they get fed, etc. But there is, I think from what I remember, there's a cooling off period for about 2 years. So that, in a nutshell, is the way it works. So if you go to Immigration and Nationality Act and go to the section on definitions, which is Immigration and Nationality Act section 101, I think. So if you go to INA, and it's available online, you can go to USCIS website and look at section 101 definition of a child. It contains both of them. One is the natural child and then the adopted child where the 2-year custody requirement is stated. *5 if you have a follow-up question. *5. Okay. So the next question I have answered many times before. Please go to my blog and go to our frequently asked questions. How soon can I change my employers once I get an approval of my green card? And the answer is, the law says on the date you received the green card approval, let's say adjustment of status approval, you must have the intention to stay with that employer indefinitely, no particular end date in mind. And the employer must have the intention to keep you there indefinitely. If a few days later you get a much better offer, as long as you can document the fact that you had the intention to stay back, you're okay. But if you change your mind, typically a few months down the road, 4, 5, 6 months, if you change, I don't think that's questionable. But if you change 10 days later, it could come up during naturalization. And I just discussed that the strangest things are coming up in naturalization applications. So somebody was telling me the other day, somebody I was talking with said, that means a lot more work for you folks. And I said, this is a bad way to make a living. We would rather make a living off of people's happiness than people's discomfort. So I certainly hope that all those things are things that you plan for, but indefinite is the key word, not permanent. So reasonable time is not the measure. Indefiniteness of the intention on the date the green card is approved is the measure. Is it a valid reason to leave because company reduced medical benefits? Yeah, why not? Problem with the boss asking for a salary raise? Why not? The company is paying $300 more than specified in the labor, so there's legally no issue. Well, there are so many ways. For instance, I'll give you an example. Let's say you get a job offer with a much bigger company and a much better location, even though the salary is less. I think that's okay. So I would not want to answer your question in the abstract. You can get an abstract answer from me, but please talk with somebody about your specific situation. This is not the time to take chances with your immigration. I don't mean to sound alarmist, but be defensive. Be defensive. Make sure that you've covered all your bases. If you get a much better job offer, like if you got your green card approval today, and 10 days later you got a job offer that says we'll pay you 10,000 more or 20,000 more or much better chances of advancement, I think I don't think government can try to make a fuss about it. I would like to take that to court. I don't think any judge can hold you back on that. I hope so. I certainly would want to, as a lawyer, test that out. I think you'll be in a defensible situation. *5 if you have a follow-up question. *5. Let's go to SG22. Need to go to India urgently. Got an H-1B approved employer, vendor, client model. I've got approval based upon I-140. What if H-1B is rejected? The visa is rejected. If my employer wishes to bring me back on an in-house project or any other project, they can do that, certainly. See, if the denial is based upon something other than fraud, a second case through the same employer or any other employer is reasonable. And they don't have to wait for lottery unless the case is sent for revocation and it's revoked for fraud or misrepresentation. Your H-4 dependents cannot stay in the USA for too long. Now, I don't know what that too long period is. Nobody in the regulation says what the too long period is, but they cannot be maintaining H-4 status if you are gone on H-1 for too long. She can continue to work on her H-4 EAD, but if you are gone too long, she'll be out of status. Visas are getting stamped, but they become more difficult. I certainly have seen people getting visas on EVC or EVVC model, as you put it. So are they easy? They never were. Last few years they've not been easy. Ever since actually it started under Obama, they became more and more difficult. But they've certainly become even more difficult now. As long as the end client can stand with you and provide information that the consulate asks for, chances are good. *5 if you have a follow-up question. Okay. So last question. Oh, there is a question from Jersey City. I'm not doing new questions, just follow-ups on what I've discussed. Go ahead, Jersey City. New Jersey, go ahead.
Rajiv, thank you very much. So yeah, I heard what you said. So basically, you said that my wife. I mean, again, this is a worst case situation. I mean, I wish it doesn't happen, but I just want to be aware. So if the particular stamping is rejected, you're saying that even if the stamping is rejected, wife who is on who's working on H-4 EAD here and doesn't plan to come with me right now, kids are studying. So she can continue to work for some time. At least in the meantime, my employer tries to figure out what we need to do.
No, see,
so
if
can,
look, hang on. It's a different hypothetical. The hypothetical that I was discussing was if your visa is delayed, not if it is denied. Okay. If it is delayed and she stays here too long, her status is questionable. If your H-1 is denied, I think her H4 is questionable right away.
Okay.
Yep. Because she derives her status from you completely. So you are the first floor of the building and she is the second floor. If you are yanked away, then she has no leg to stand on. Okay?
So is there any regulation in this? Or this
No,
is
I definitely cannot point you to any regulation. I don't think there is any regulation. But government does not always rely upon regulations to issue their decisions. Sometimes it's a matter of policy. I'll give you an example. There is no regulation. You'll be surprised to hear this. There is no regulation, and I've studied this, that requires a specific job for an H1. There is no requirement. But as a practical matter, government has derived this to be the backbone. In fact, they have prosecuted employers criminally for offering a job that doesn't exist yet. And that's part of what we are arguing before the court in one of the criminal defense cases that I'm assisting with. So these kind of situations are matter of policy. Can government get away with it? As long as you don't take them to court, yes, they can. And taking them to court is expensive and takes time. Okay?
Okay. So one last thing, I know you mentioned beginning that DS 160 something you would like to have assisted, you would like to assist on that. But a very generic thing, which probably is a very important thing. There was a question which said, are you applying in the same category and at the same place? There is one question and two parts. And so for me, I applied the previous visa, same H-1B, same employer in Sydney, Australia actually. And so the answer to that part is no.
Sir, let me stop you. Let me stop you. I will not be able to answer your question for two reasons. One, until I see the language of the question specifically, I don't know what the answer is. And two, if I look at the language of the question, I can't answer the question anyway because that's filling out forms. So no, I won't be able to answer that. Ask your lawyers. Okay?
Okay.
Good luck.
Thank you.
You're welcome. Okay guys, even though I don't have time, but a lot of you have waited a long time, I will answer any questions you have and I'll do my best in the next 10-15 minutes. So anybody has any question, raise your hands. Press *5 on your phone. 1, 2, 3. 1, 2, 3. Okay, no more than 3 questions and that's the end of our conversation today. I'm always delighted to talk with you, but let's do these 3 questions and then we are done. Okay, let's go first of all to, what did I just do? Let's go to Pennsylvania. Pennsylvania, go ahead. We can hear you.
Sure. Good afternoon, sir. First of all, thank you for helping people out here, and I really appreciate it, and God bless you.
Thank you.
For your effort.
Thank you.
My question is basically about the consular processing, and I did initially ask that question. So in my case, first of all, the consular processing, I have no idea what it is. And I did ask some questions about consular processing. It said it's an uphill task, and these days consular processing is like is very difficult to get consular processing.
Okay, hang on one second. Let me interpose a question. First of all, consular processing simply means that you are getting something done from the consulate rather than from the USCIS. That's all it means. But it can come in the context of an H1, L1, L2, H4 or a green card. What are we talking about? Non-immigrant visa or green card?
So I'm talking about H-1B. I am
Okay.
H-1B
Okay.
with my vendor model.
Okay.
And I have a Canadian permanent residency. I want to move to Canada with all this unpredictability which will stay on for 10, 20 years. We don't know. I wish to move to Canada, but still I have 2011 priority and I want to maintain that. Don't want to lose my employer. At the same time, I want my Canadian PR not to be lost and living in Canada, coming back to US. So if I move with my file moves, what exactly happens in consular processing? Does the employer have to initiate something on his end by sending my file to Canadian?
Oh, no.
US consulate?
No. Okay. Now, do you want to maintain your H1? Okay.
to maintain.
Hang on. Let me just answer my questions precisely so I can understand what you're thinking. So you want to maintain your H1, but you want to live in Canada. Would you be visiting USA?
See, if I have no job in US, I may not be visiting USA.
Okay.
Because once I've been my client, I have a perfect job right now, but I'm willing to give up that job and live in Canada.
Okay.
So one
Let
question,
me hang on. No, stop. Your question is going to be long. I'll spend some time with you. Let's go ahead and answer other people's questions. Hold the line, okay? I'll be right with you. Let me go to people who've been holding for a long time. Missouri, we can hear you. Missouri, go ahead.
Hi, Rajiv, sir. This is Ballin 3. I just have a quick follow-up question for the H1 transfer.
Yes.
So, as far as I remember, there's no premium processing.
Yes.
So how long can I work while the transfer is pending?
No. No.
How would that process work?
You cannot work while the transfer is pending after your OPT expires. Okay? So, I'm not even sure. Yeah, you can work on your OPT till October 1st. After that, you can't work unless the H1 is approved, but you can stay in the United States.
Okay, so until the transfer is pending, I'm legally,
Oh yes,
right?
you're authorized to stay. And remember, if premium processing is restored, you can always premium a pending case.
Okay.
Okay?
All right. Thank
You're
you.
welcome. Good luck. Okay. And we have one more question from Pennsylvania. Yeah, Pennsylvania, go ahead, please. We can hear you.
Hi Rajiv, good afternoon. I have one question.
Yes, sir.
Say I have like an EAD from my employer A, and after 180 days, if I move to employer B by filing AC-21, while filing AC-21, do I need to file any other supporting documents like employer B's offer letter or employer verification letter or anything like that along with AC-21?
File supplement J. That's what I would recommend. Supplement J.
Okay. Along with that, do I need to submit any other supporting documents?
Read the instructions on supplement J. Just follow them. You don't need to do any, actually have your lawyer do it. It's not something you should be doing. But supplement J doesn't require any supporting documents as far as I remember.
Okay.
Give me 1 second. Let me double check that.
This is not a valid menu option.
Hello? Does supplement J require any add-on documents or just the supplement itself? Thank you. Yeah, no additional documents. Okay?
All right, Rajiv. Thank you very much.
You're welcome. Good luck.
Thank you.
Okay, now let me get back to our Canadian friend, which is the last call of the day. Okay, can you hear me okay?
Thank you. Yes, I can.
Oh, I'm not going to answer any new questions. I'm sorry. California, you can put down your hand because I already told you I'll do 3 questions, no more. Okay, so going back to your question. First of all, remember one thing. For the next 6 years, you will not be subject to the H1 quota. You can always come back unless they change the laws. Okay, so even if you leave USA and don't work for any US employer, you can get your H1 processed again if you have time remaining on your H1. If you have a green card going, you can keep getting H1 extensions based upon I-140 approval or I-140 approval is what you would use. That's number one.
With
Now,
the same employer, right?
any employer. If an I-140 stays unrevoked for 180 days, the benefit of H1 extension is always available indefinitely with any employer.
So how will my employer maintain my H1 even if he's not running my paycheck?
Well, you don't have to maintain the H1. The law says anybody whose H1 was approved in the last 6 years, even if they stop working and they go away, they are not subject to the quota for the next 6 years. Okay?
Okay.
So you don't have to maintain the H1. Of course, second point, which is important, you can always work from Canada on work that is outsourced to you and you don't have to be on H1 because you're working from Canada. Number 3,
Right.
once you get Canadian citizenship, then you will not need a visa. You just need an H1 approval from any employer. Okay?
Yeah, then I come on T1. Yeah.
No, you can even come on H1 and you won't need a visa.
Oh, wow, wonderful. Okay.
Yeah. See, Canadians need, I think, only 2 visas, E visas and K visas. Other than that, if you're coming in as a treaty trader, treaty investor, you have to go through the visa process, or you're coming in as a fiancé or a husband, you have to go through. But any other visa, H1, L1, L2, H4, if you're a Canadian citizen, you do not need a visa. Okay?
So what do I ask my employer to move my file for council property?
You don't have to do anything.
He's evident.
You don't have to do anything.
Why don't I have to do
That was my last point. That the fact is, when you file an H1, a complete copy of your H1 file, including the approval, gets uploaded to a central database called PIMS, which is available to all consulates all over the world. You don't have to move any files.
Oh, yes, my PINs is updated, so that's I know for sure.
Yep. Okay?
So I don't do anything, just leave.
You
and,
just leave.
work in Canada
And if
with
you,
some ABC
yeah,
Google company.
yep,
The
absolutely.
only thing I need to have is ask my employer not to revoke my 140.
Well, when was your I-140 approved?
It was 2011, late 2011.
Even if they revoke it, it doesn't matter anymore. You have complete benefit since from January 17th onwards. Anybody whose I-140 stayed approved for 180 days, they have the right to carry their priority date and the right to extend H1 through any employer, even if the I-140 is revoked.
Thank you so much. So I'm living in Canada and my date becomes current. The only thing I will need an employer to file my labor in 140 again, and my priority date will be 4 days, right?
That is correct. Okay.
Wonderful. Thank you so much. And again, Rob, you are helping people here, and these people are in so much trouble because of this system.
Don't worry.
So thank you so much.
That's what we are here for, all of us together. No worries. We'll deal with it one thing at a time. Okay.
Thank you.
Good luck, sir. Guys, everybody, so good to talk with all of you. Unfortunately, my time is limited. If I had more time, I would like to spend hours upon hours with you. See you again in 2 weeks, okay? Take care, everyone. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.